right. Can everybody hear me okay? All right. Thanks, Kitty. Okay, so in my job, I encounter a lot of helpers, as much as I'm sure you guys encounter helpers. People that your residents or your patients trust to handle things for them, because they either can't physically do it themselves or they have deficiencies that don't allow them to undertake this decision making for themselves. So what the aim of this presentation is really geared toward is to give you some basics on identifying these types of helpers, what their roles are, what their authority is, as well as some pitfalls to avoid when interacting with these different types of helpers. So we talk about everyone needs a helping hand at some point, right? We can't do everything for ourselves, despite the fact that we might try. We're going to need to rely on some other person at some point in our lives. So when we're talking about helpers, we're generally talking about one of two categories. We're talking about medical helpers or financial helpers. Now, medical helpers are typically a guardian, maybe a court-appointed guardian, that somebody has been appointed by the court to make decisions for this person. Or maybe we're dealing with someone that the patient or resident appointed for themselves. So maybe we're talking about someone who is acting as a patient advocate. This is also sometimes referred to as a health care power of attorney. And I know that causes a little bit of confusion. Bob mentioned it earlier. Just because someone's document says it on the top doesn't mean that that's what they actually are, or that doesn't mean that's what the document actually is. On the financial side, we're often dealing with a conservator. So this is also someone that's appointed by the court to make financial decisions for someone. Or if we don't have a conservator in place, maybe we're dealing with someone who's acting under a durable power of attorney. Now, this person's typically called an attorney in fact or an agent. So this is someone the patient or resident trusts to make financial decisions for themselves. All right, so when we're talking about medical helpers, Bob mentioned earlier that we're typically talking about someone who has been deemed incapacitated. So somebody else is stepping in their place to make decisions for them. So when most people think someone being incapacitated for medical purposes, they think someone is unconscious, right? They can't make their own decisions physically because they don't have that ability to communicate what they'd like. But I'm sure you all know that that is a lot broader in reality. We're often dealing with people with mental deficiencies, either because of Alzheimer's, dementia, other issues that are happening that are not enabling them to make medical decisions for themselves or participate actively in that decision-making process. So one type of medical helper that we often deal with is a guardian. Now, guardian has a very specific legal definition, okay? You can't just declare yourself guardian over someone and be like, all right, I'm good, I'm the guardian of mom, I'm gonna take care of mom. No, it's a court process, so that means you have to go through this formal legal process in order to be appointed as a guardian. Now, what do guardians do exactly? So guardians typically handle all social, custody, and medical decision-making for the person who's incapacitated, who's referred to as the ward. So they're making all decisions about where the ward lives, who they interact with, what kind of medical treatment they're going to have, or in some cases not have. The guardians have the authority to make all of that. Now, typically, guardians are not dealing with financial decision-making. They manage monthly income, but that's about it. In some circumstances, the court may grant a guardian authority to make decisions with regard to financial assets, but it doesn't automatically mean by being appointed guardian, you have the ability to control the financial assets. So how do you become a guardian? Well, I mentioned earlier it's a formal legal process, so it's generally meaning court. Someone has to file a petition seeking that a guardian be appointed for the ward. Now, this is typically done by an interested person. Normally, that's a family member, but it doesn't have to be. If there's not a family member that is willing to step in and take action for the ward in this case, you, as the facility, can actually make the petition to have a guardian appointed. Now, you can't, as the facility itself, act as the guardian. You can't do that. But you can step in and take action if you think that someone needs a guardian to be appointed to start making decisions for them. It typically involves a hearing, because like I said, it's a court process. And at this hearing, you typically have to present evidence that the ward is incompetent. Now, what do we mean by incompetent? We have to show specific and a few instances of the ward not being able to make decisions for themselves. So either because they're acting against their own interests, they're doing things that are putting them at harm, or they just are not able to make those decisions, to take action. Now, this is a high standard because what we're doing when we're appointing a guardian for someone is we're essentially cutting off that person's legal authority to make decisions for themselves. So we're telling them you can't decide where you get to live anymore, who you get to interact with, what kind of medical care you're going to get. So we want that burden of proof to show to the court saying this is necessary. We need to do this. So that's one of the highest legal standards we have, is this clear and convincing standard. So you have to be able to bring the evidence showing that that is necessary in this case, to cut off that ward's ability to make decisions for themselves. Now, if the court is convinced of this, they essentially issue letters of authority, and this is the permission slip for the guardians to be able to take action. It's their little piece of paper that says, I get to make decisions for this person. Now, I know Bob talked about earlier that there's some differences between when we're talking about competency and the capacity to execute legal documents. This is a very confusing area of the law. It causes a lot of miscommunication. So I wanted to take a few minutes to clarify this for you. So when we're talking about competency, we're talking about, does the person have the mental ability to make informed decisions for themselves? So basically to participate in their medical decisions, financial decisions. Do they have the ability to balance their checkbook, understand what the doctor is telling them, and make decisions about their care or the alternatives being offered? This does not mean that if somebody's determined to be incompetent, that doesn't mean that they don't have testamentary capacity. So capacity and competency are often used interchangeably. There's a very subtle distinction between these two. So when we're talking about testamentary capacity, if they don't have the ability to make that decision for themselves, they know, I can't balance my checkbook, I can't talk to the doctor in an educated format about my decisions, I don't understand what he's saying, I need help. Do they have the ability to at least know that they trust their son or their daughter or whoever they are appointing to say, I can't understand this, but I trust my son to make this decision for me? When we're talking about testamentary capacity, it's a much lower threshold than this higher level decision making. Typically what we're looking at for testamentary capacity is, can you name your children? Do you know who they are? Do you know what assets you have? Do you know you have a bank account? Do you have a house? Maybe you're not naming it down to the penny of what's in there, but do you know what's out there? And also, do you understand that you have the ability to appoint someone else to make these decisions for you if you can't do it for yourself? So really what this is doing is the law is enabling us to appoint someone that we trust if we recognize we can't do it for ourselves anymore. So it's important that we understand, even if someone's determined to be incompetent by all medical standards, we're saying you can't make active decisions for yourself. It doesn't necessarily mean that they can't execute new estate planning documents. So you might see our office come in sometimes to your facilities to meet with clients, and maybe they don't have that ability to have that high-level decision-making, but they can do all those things that I just talked about as far as naming their kids. They know approximately what they own. They know that they can appoint someone else for them, and they know that that document is essentially doing that. So rounding back to guardians and what they can and cannot do. Guardians, if you're seeking to be appointed as a guardian, or if you know a family member who is seeking to be appointed as a guardian and they have a felony record, there's no legal bar necessarily to being appointed a guardian if you have a felony record, but I don't know many judges that are willing to appoint somebody who has a felony record. And what's becoming more and more common with these petitions to the court is courts are actually requiring background checks. So they're having you fill out this little background check information. It says you got to fill out all this stuff, and they'll run a criminal background check on you, just like any other employer or whoever might be running the process on you. On top of that, I'm also seeing them kind of go outward, that if you have other people living in your household, they might do criminal background checks on them as well, if they're going to be exposed to the ward. Another thing, and I know Bob touched on this earlier as well, it's a legal process, right? Guardians, they're supervised by the court. That means it's smooth, right? They return your phone calls quickly. They pay their bills on time, right? Now, just because it's a court process doesn't mean that there aren't pitfalls. Doesn't mean that the person appointed is going to be doing everything that they're supposed to do. Just like any other process when we're dealing with agents, if they're not doing what they're supposed to be doing, somebody needs to know about it. And it doesn't mean that just because the court's involved, everything's going to go perfectly fine. All right, so there's a lot of work involved when you're appointed as a guardian. It's a court process, and anything in the legal field is never that smooth, right? So typically, a guardian is going to have annual reporting requirements. Every year, they have to submit this report to the court telling them all the things that the ward has done and everything that you've done on behalf of the ward as the guardian. So every year you have to file this, and there's a very strict deadline in which you have to get this in, and if it's not in, you're going to get a very nice, nasty letter from the court saying you need to file this. Top of that, you need to have regular interactions with the ward. Now, this is pretty self-explanatory that if you're reporting to the court all the things that you're doing for the ward, probably have to meet with them. But that's a part of the guardianship that's going to take up more time of the guardian to meet with the ward, make sure their needs are being met on a regular basis. Now, a guardian's authority is also not a blanket authority. Sometimes you're going to need to go back in front of the court to get permission to do certain things. So if you need to do something, let's say you're managing the assets, you have permission from the court to manage the assets, but it doesn't outrightly say that in your letters of authority, and the life insurance company won't talk to you. You might have to go back into court as guardian to get a court order allowing you to interact with the life insurance company. Now, sometimes this work is necessary. So it is a lot of work, and it's an extreme. Like we said, it cuts off someone's ability to make decisions for themselves. But sometimes it's a necessary step that has to be made. It can't be avoided at all times. We try to, but sometimes the circumstances justify this high interaction. So for example, we had a gentleman in our office who was suffering from Lewy body dementia, among some other health issues. And he was actually hallucinating a man with a giraffe head in his room. Absolutely terrifying if you can think about that. But the problem was, he could trick family members who didn't interact with him that often, or other people that were visiting that just didn't interact with him that often, to think that he was perfectly fine, that he's not having any problems at all, and they're holding him in the facility against his will. Well, eventually, more and more people had stories that just weren't adding up, and it was determined that this gentleman could just be very convincing, that he didn't need help. And in reality, he was putting his own health at risk. So in that circumstance, we went to court and we got a guardianship over him. So now he couldn't make his own decisions anymore because it wasn't in his best interest. We wanted to make sure that he was taken care of. So guardianship is not always the worst thing, but when necessary, we shouldn't hesitate to use it. Now, another type of medical helper is a patient advocate. So instead of someone that the court appoints for the ward to make decisions for them, a patient advocate is somebody that your patient trusts, that they've appointed for themselves to make decisions for them. Now, a patient advocate doesn't get to make all decisions for them, so it's not like a guardian who gets to make care, custody, control, social interactions. A patient advocate is typically only making decisions about health care, so their authority is a little bit more restricted. Now, also, they're bound by the document. So a patient advocate designation or a health care power of attorney is the authorizing document that gives that person authority. So if the patient advocate doesn't allow their patient advocate to, or the patient advocate designation doesn't allow the patient advocate to sign a DNR, then the patient advocate doesn't have that authority. We have to look at the document and see exactly what's provided. So what makes a valid patient advocate valid? Has to be made by someone 18 years and older. The patient has to be of sound mind. Now remember, that's that testamentary capacity I talked about, so it's that much lower standard. Do they have the ability to recognize their family, their assets, and the ability to understand that they can appoint someone to make decisions for them if they can't do it for themselves? The designation has to be in writing. It has to be signed and dated by the patient. Now on top of that, there's some witness requirements that trip up a lot of people. It's got to be witnessed and signed by 2 independent witnesses. Now, what do I mean by independent witnesses? If you're related to the patient, you shouldn't act as a witness. You have to be uninterested. Also, employees of the facility where the patient is residing should not act as a witness. That will not make the document valid. It's counterintuitive to what we're trying to do. We're trying to help them. Now, the patient advocate also has to become part of the medical record of the patient. So the attending physician should have a copy of it on file. Obviously, if we're interacting with those people, we want to make sure that they have the documents to back up that the patient advocate has the authority. The facility where the patient resides should also have a copy, and the document should be reviewed annually. Make sure that all those execution requirements are met. Check your witnesses, make sure they're not related, or if they're employees of the facility. The capacity should also be evaluated of the patient every year. If you're the one actually communicating with the patient advocate because the patient doesn't have the ability to make their own decisions anymore, that should be reevaluated every year to make sure that the patient hasn't regained competency. If they can make their own decisions, it's inappropriate to look towards the patient advocate for that type of decision making. Now, on top of that, the patient advocate themselves has to sign an acceptance, and that has 10 statements that are set out by Michigan law that they have to agree that they'll abide by, and that has to be signed by the patient advocate before they can act. So Bob talked about this a little bit earlier, that you can't appoint someone to make medical decisions for yourself unless you have been deemed incapacitated or incompetent. So how do we get there? It's typically the 2 evaluations rule. So we're looking at least the attending physician and 1 other medical professional, another physician or a licensed psychologist, making the determination that after an evaluation, the patient doesn't have the ability for this high-level decision-making anymore. Only at that point does the patient advocate have the authority to make decisions. Remember, prior to that, it's the patient. And this can be a kind of a fluid concept, as I'm sure you're aware. I'm sure you all have patients who in the morning are perfectly fine, and in the afternoon can't remember anything. So it could be a fluid concept, and you can regain capacity later on. If it's a medication combination that's causing a little bit of a hiccup, later they're off that medication, they're perfectly fine, they can regain capacity and make their own decisions. So we have to evaluate this consistently. So what about mental health treatment? Now, we never have a patient in a facility suffering with mental health issues that's non-compliant, right? Everybody with mental health issues is perfectly fine. I'm going to stay here. You're going to get me treatment. Everything's going to be great. Well, no. So the patient advocate can actually address this. Now, when we're talking about patients that are suffering from Alzheimer's, dementia, those medication reactions I talked about, those UTIs that Ina was talking about earlier, any of that could cause some mental health issues that might be addressed by the patient advocate. So, if the patient is having mental health issues and is distrustful of those trying to help them, our concern is that they might fire their agent, say, I don't need you anymore, I'm going to make decisions for myself. Well, then what do we do? How do we make sure that our patient who still needs help is getting the appropriate help? So a patient advocate does have the ability, if their document allows them, to have this 30-day cooling off period. So that's where even if the patient says, I'm done with you, I don't want you to make decisions for me anymore, if the patient advocate has this authority, they get 30 days before their firing is effective, and they get to make decisions for that person, continuing. So what does this do? This buys us time. So in the event that the patient is non-compliant, they fire us, we still have 30 days to get them help. Now, the problem is a lot of patient advocate designations do not have this language in there. Good news is ours do. So if you're working with clients from our office, then chances are they've got this in their documents. But the vast majority of patient advocate designations do not have this language in there. So that's why we need to look at that document, and we need to make sure that we understand the patient advocate's abilities. So some other fun facts about the patient advocate. Patient advocate can't delegate their authority to somebody else. So if the patient advocate is out of town and they just can't get to the facility to make the decision, they can't designate their husband who's back in town to make the decision for them. Doesn't give them that authority. Another one that I see quite commonly is you can't have co-patient advocates. I get a lot of people that are like, I trust my son and daughter equally. I want them both in charge. Well, if you try to appoint them both in a patient advocate designation, it actually can make the document invalid. The law does not allow for co-patient advocates. Okay. Some other challenges that are brought on by the patient advocate is that revocation thing that I talked about earlier. So you can actually fire your patient advocate. And the resident can revoke the patient advocate at any point so long as they are able to communicate the revocation. So it could be something as similar as, I don't want you to act for me anymore, I'm going to make my own decisions. So one way to address that is that 30-day cooling off period if the revocation is coming from that mental health issue. But the important thing to remember is this can be done even if they're determined to be incapacitated or incompetent. So even if you have two professionals that say they can't make decisions for themselves, they can still fire their patient advocate. It's a weird thing with the law that a lot of people aren't aware of, but you can fire your patient advocate at any point that you're able to communicate that revocation. Now, another thing that can be a challenge with the patient advocate is removal. So you might be removed as the patient advocate by the probate court for a variety of reasons. Now, sometimes removal is not a bad thing. Sometimes it's because we need that guardianship, because we need that higher level of interaction at that point. So the patient advocate could be sidestepped by the guardian. Some other ways that the patient advocate could be removed is if the document's not valid. So if they're not valid, then their authority is not valid, so they're removed. They don't have any ability to act. Another way is if the patient advocate is just not doing their job properly. So typically I see this as when somebody is applying for a guardianship and that person's not the patient advocate because the patient advocate's not doing anything. Well, the court in that case might remove them. So I've already addressed this earlier, but just to hit on this point again, it's really important to have a clear and complete copy of the document. I can't tell you how many times I have clients come into my office and I ask them to bring their old documents so we can look over everything. And they'll give me the patient advocate designation, and I'll start looking through it, and it's pages 1, 2, 4, 5, 9. I don't have a complete copy of the document, so I don't know what their authority is. I'm sure you've had this yourselves, where family members come in and you ask for the patient advocate, and they give you the durable power of attorney for finances. People don't understand the differences between these documents, so that's why it's important that we have to look at them and make sure that we've got complete versions of everything so we know that their authority is valid and what the scope of that authority is. We also want to confirm that they're signed appropriately, that the acceptance was done, and that we have those appropriate witnesses. So do not resuscitate orders. This is something that your helpers might encounter, or patients themselves might encounter themselves. So what is it? Well, do not resuscitate order is basically a document that directs that in the event of a medical emergency outside of a hospital, we don't want any heroic measures to be taken. So who has the ability to sign a DNR for the patient? Well, obviously the patient does if they have the ability to make decisions for themselves. They clearly have authority too. But what about those circumstances in which it's not clear or that they don't have the ability to make the decision for themselves? What helpers can we look to before we can execute a DNR? Who has the proper authority? Well, a patient advocate can, if the document allows them to. That's why we need that clear, complete copy of the patient advocate so we can look at it and see, do they have the authority? And it may not expressly state they have the authority to execute a DNR. We have to look at it closely and see, What are the exact parameters that the patient advocate has? Now, guardians can also sign a DNR. This is where it gets a little fuzzy, though. Guardians that were appointed after February 4th of 2014 clearly have this authority. The law was amended to clearly state that guardians have the authority to execute a DNR. Now, they have to do some steps, as with anything else. They've got to at least meet with the patient not more than 14 days prior to signing the DNR. They have to consult with the patient if meaningful conversation is possible about whether or not they would want the DNR executed. And then they also have to meet with the attending physician of the patient to discuss the particular circumstances or medical conditions that would warrant signing this. And then every year, they have to reaffirm the DNR by talking to the patient and talking to the physician to make sure that this is still something that's appropriate. Now, for guardians that were appointed prior to February 4th, 2014, your best case is to really go and get approval from the probate court. The law was wonky on it. It really wasn't clear on whether or not they have the authority to do it. So best practice is going to be take the time, go in front of the probate court, get an order that allows you to execute a DNR. Follow the same steps as the current law, and it should be okay, but you're going to want to get that approval from the probate court. Now, requirements of a valid DNR, it's just like any other document. Yes? Okay. So there is a solution for that. It's called a petition for instruction, where you're in that kind of limbo land and you need direction. You can actually petition the court for instructions about what to do. That's definitely something that could be appropriate, and we'll actually get into that a little bit later too. So for DNRs, we're looking patients 18 years older, have to be of sound mind, or they're executed by someone who has authority to do it, so they're helpers. Got to be signed by the attending physician unless it's solely for religious purposes only. And it's got to be executed by 2 witnesses. At least one of the witnesses cannot be related to the patient. So this is a developing area of the law, this physician orders for scope of treatment or post. And Bob's going to get into this a little bit more in hot topics, but I wanted to do a little introduction for you guys. So this is a new law in Michigan. It's not totally effective yet because they don't have the form finalized for it, the actual post form. We're hoping to have that by the summer, but it's currently in the development phase. And what this tool is really aiming to do is to bridge the gap between the patient advocate designation and a DNR. It's also aimed to be universally accepted, so it's part of their medical record. No matter where they're at, the post form will be accepted. It's not for everybody. Not everybody in this room should have a post form. Actually, I would say probably no one in this room should have a post form, because it's only for patients with serious advanced illnesses, basically circumstances where their physicians would not be surprised if they passed within the next year. All right, so financial helpers. If we're moving on to, yes?
If I have the DNR, I've already signed and get notarized, isn't that just automatically in effect because that's what I want?
Not necessarily. So the DNR law actually requires that it be through that process, so you've got to consult with physicians. It's a physician order, so it doesn't necessarily mean that that's going to be applied. You have to look at the particular facts and circumstances of it. So you typically can't advance a DNR ahead of time, and even then it might be limited. There's a lot of miscommunication when it comes to this. Unfortunately, hospitals typically have you fill out a lot of information. It doesn't necessarily mean that it's always appropriate. And it could also be in the circumstances that it did arise, but it doesn't mean that it's universal. Financial helpers, so someone who is going to have the ability to make financial decisions for you. This is similar to those medical professional helpers, but this is aimed more so at someone who we trust to manage our assets. Now, one type is a conservator. It's very, very similar to a guardian, right? You can't declare yourself. A conservator has to be appointed by the court. It's a very similar process to that of a guardian. They manage income, but they also manage assets. They have fiduciary duties, meaning they have to spend and invest the money properly and reasonably. Now, often the guardian and the conservator are the same person, but that doesn't mean that they have to be. The court might appoint one person as conservator and a different person as guardian, either because they're suited differently or they want to split the duties for whatever reason. It can be different people. So that conservator process is very, very similar to that of getting appointed as a guardian. It's a court process. You have to file a petition. Facility cannot be the conservator, but they can file the petition. It's that same level of clear and convincing evidence that has to be met, so we're cutting off somebody's ability to make decisions for themselves. And if the court is satisfied with everything, they will issue letters of authority. That's the conservator's permission slip. So there's a lot of work involved in being a conservator as well. There's ongoing court supervision. Every year you have to file an annual account, down to the penny, showing where all the assets are. Certain courts will require you to appear in front of them at least every couple of years to explain where the money has gone, to explain the accounting. And on top of that, the conservator's authority is not blanket, just like a guardian. There are specific things that they need court authority to do. Most notably, before the conservator can sell off real property assets of the conservator or of the ward, they need to go in front of the court and get permission to do it. And additionally, sometimes the court will say that the money is held in a restricted account, meaning that they have no access to it unless the court says that they can invade it. Prior to that, touching that money is actually against court orders. Now, another type of financial helper that's not appointed by the court is that durable power of attorney. So that agent in fact or attorney in fact under a durable power of attorney. This is someone the resident trusts to handle their financial affairs. So it's not involved in court. Now, Bob mentioned earlier there's a lot of different types of powers of attorney. There's springing, which come into effect upon incapacity, similar to a patient advocate. And then there are ones that are effective immediately. So we got to look at those documents to determine what exactly this one is. They're also general, which gives broad authority, or maybe they're specific. You can only do one type of thing, or you can only handle one type of asset. Do they have extraordinary powers? Do they have those authority to make transfers that might be needed for different types of benefit planning, like veterans benefits or Medicaid? This is going to be very, very similar to a patient advocate. 18 years or older. It's got to be signed by them. It's got to be witnessed by 2 independent witnesses. And the attorney, in fact, has to accept their duties. Now, this is also a newer law. In 2012, October 2012, this law went into effect requiring that agents sign an acceptance. Now, it doesn't mean powers of attorney older than that are not effective. But what I've run into is that financial institutions will give more pushback if they don't see this acceptance. They're looking for this acceptance. So best practice is to actually just have them sign one. I've hammered this to you guys enough. Have a clear and complete copy. Make sure that we know what the document's about. So what do we do if our resident has nothing? This is a very common question that Bob and I get a lot, is, well, what if I don't have any documents and there's no time for a guardian or a conservator? What do we do? Well, your first step should be evaluating that testamentary capacity, or having us evaluate that testamentary capacity. Can they sign new documents? Do we have the ability to have someone be appointed by the resident or the patient? If so, then we've solved our problem. They have documents now, so in the event they can't make decisions for themselves, we've got a plan in place. If your resident cannot sign new documents and their medical condition requires immediate action, this is where we're talking about a little bit with that temporary guardianship. A temporary guardianship is a possibility. You can go into court and get a temporary guardian appointed. Now, eventually a permanent guardian is going to be reported, so it's typically 2 court hearings at that point. But if you need immediate action, this is an avenue. Now, another option is a petition for instruction. So if nobody's doing anything, but we need some direction about what should happen with the award, well, we can go and ask the court for some instruction. Tell us what to do. And that can help reduce your risk. So if your resident cannot sign new powers and there's no time for a temporary guardianship, here are some things to consider. If all the family is on board, mutual agreement, consider looking towards the family. There's some legal support for this, and it's less risky if everybody's on the same page, but the legal support's a little vague, and that's what I really want to touch on with you guys, because there's a lot of misconception in this area. So some states have a general family consent law. This is basically a law that provides that if the patient's not able to make decisions for themselves, a family member is the next one that can make it. They typically set a specific order, so spouse, then kids. Michigan does not have a general family consent law. There are a lot of people I talk to that believe Michigan does. We're actually not one of the states that has one, and there's nothing in the legislature that indicates that we're going to be getting one anytime soon. So what's important to note is spouses are not considered natural guardians for each other the way that parents are for minor children. So those of you with children under the age of 18 at any point know that you get to make decisions for them. It's not true with your spouse. There's no legal authority that actually allows you to make decisions for your spouse without some kind of document in place. What Michigan does have is 2 laws. The one that is probably more relevant is the Social Welfare Act. And this is basically that if someone doesn't have the ability to make decisions for themselves, and they're governed, their situation is governed by the Social Welfare Act, meaning that they're in a nursing home or others enrolled in Medicaid. It says you can look towards the family members, but it's an imperfect law. It doesn't state a priority for which family members can act. So do we look to spouse first? Do we look to kids? Who do we look to? It also doesn't define what we mean by sound mind. Now, typically best practice is to follow that 2 evaluations practice, but the law doesn't explicitly say that. The other law is the Dignified Death Act, and this is basically a law that requires that physicians provide information about the recommended course of treatment and alternatives to the patient, and if the patient's not able to receive them, to the family members. So if the patient's not able to give consent, the physician provides all this information to the surrogate. And the surrogate's defined in this act as a member of the immediate family, next of kin, or legal guardian. But again, it doesn't define a priority, so we don't know who we're looking to. It also doesn't give us any guidance about sound mind. So our best practice is if everybody in the family agrees, everybody's on the same page, it's less risky. We have less risk involved if everybody is on the same page. But there's nothing in the Dignified Death Act that explicitly authorizes this. It's an implication. So remember that there's nothing that it specifically authorizes people to make those decisions, but if we have family agreement, we're reducing our risk. But if the patient is not on Medicaid or in a nursing home, then there's no authority that we can rely on. So generally the status quo is going to be to preserve life to the greatest extent possible. Custom might dictate otherwise. If we have that family agreement, our risk is reduced by moving forward. If not, our possible risk are lawsuits, citations from regulatory authorities like LARA, etc. So in conclusion, just to sum up everything that I just thrown at you, is there are a variety of helpers, and each one has their own different types of challenges, authority, and limitations. The important thing that I really want to hammer on is this difference between testamentary capacity and competency. Just because they can't participate in high-level decision-making does not mean that they can't sign new estate plan documents. Document your records carefully. Make sure that you have complete versions of the documents. And also proceed with caution if there's no legally clear helpers. Consider the alternatives first, but if you get that family agreement, your risk is reduced. All right, thank you. I know we're a little short on time. If you have questions, find me afterwards. I'm more than happy to talk to you guys. Thank you.